Welcome and thank you for joining Seyfarth's webinar, Latin America Reductions in Force, 10 Things to Look Out For. All participants are in listen-only mode. You're encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down as it will not be repeated and it's required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Anna Sid. Anna, you may begin.
Thank you, Sophia. Good morning, good afternoon, everyone. Thank you so much for joining us today in the third of our series that we've been doing at Seyfarth, International Employment Team, covering the reductions in force. My colleagues around the globe have already covered EMEA region and also APAC region, and today we're going to focus in LATAM, Latin America, and we're going to discuss the 10 things to look out for in the reductions in force. So today I am joined by my two wonderful colleagues that are going to be presenting with me on this matter. First, starting from the right, Dan Wallman, who's also an international partner in the New York office. He does support the world's best-known companies through their most complex international workforce challenges in a very commercial manner. He's US qualified, admitted in New York and California, and helps translate corporate strategies into actionable tactics at a country-by-country level. And also here in New York, Juanita Vera is Colombian qualified and provides comprehensive international employment law advice to multinational companies on their unique challenges. Along with them, myself, also international employment partner based in New York. I am Spanish qualified and I do support my clients around the world in employment legal matters, but with a special focus in Latin America. So moving on to the agenda for today, what we have designed as these 10 things to look out for are the following items. So first, we're going to talk about planning and strategy and also the timing for our restructuring in force, also the rationale for the restructure, the selection criteria for those employees that might be impacted by the restructuring, any consultation obligations, labor authority involvement, the severance cost and benefits, timing challenges, logistical and practical implementation of the restructuring in force, post-employment consideration once the restructuring has been executed, and then last but not least, the risks that a reduction in force might involve. So moving right into the first topic, the planning and strategy, what we are going to discuss today is the overall big picture that the planning and strategy requires. And to start with, I would like to invite Dan to give a little bit of the comments on how this overview planning and strategy might be different if you look at the LATAM region compared to what the US perspective would look like.
Thanks so much, Anna. Hi, everyone. Good day to you all. Thank you for joining us today. The starting point for this discussion is the same starting point I take in every one of these webinars when we're trying to differentiate the United States from the rest of the world. And here we're, of course, just talking about Latin America. One of the things that sets the United States apart is the fact that we have employment at will. It means that employees, among other things, it means that employers are able to dismiss employees for any reason, with or without cause or notice, and except for an illegal reason. So the world is wide open to employers in the US to dismiss people. The only reason we have to be mindful of it, as I'm sure everyone on this webinar knows, is to minimize litigation risk from employees after the dismissal has taken place. This is in stark contrast to what we would see across Latin America, where because there is no employment at will, the issues that we're going to talk about often have to do with whether or not the employer is even able to make the decision to dismiss in the first instance. So I just ask you to please keep in mind that employment at will and everything we know about it is perhaps the biggest wedge between understanding how we do these things in the US versus how we would do them elsewhere. Back to you, Anna.
Thank you, Dan. And I think that's a very good set of the scene. And I think what we are presenting in this slide is like the overview of the requirements for the reduction in force in the country. And we've done this kind of heat map to present the different complexity in the countries. And to be honest, I mean, we've based this on a criteria, and we're going to explain that what that criteria looks like. Because if you ask, based on a different criteria, the color coding that we've included here might change. And also, if you like, if you ask in another moment, the perspective might be different. But I think this is kind of a good starting point that we always recommend our clients when doing a reduction in force, which is understand the legal framework of the country, because the regulations will be different. As Dan was explaining, there are different requirements in terms of how you can terminate employment in the different countries. The concept of employment at will just doesn't exist. And therefore, there needs to be a process, and the process will be easier, medium, or hard, depending on where we're looking at, and also the perspective that we include. So we've classified here as easy, medium, or hard jurisdictions. In the easy countries, we've included Chile and Costa Rica, and this is because basically we consider, based on our experience and working in these countries, is that it's relatively easy based on the local regulations. It's relatively easy to do reductions in force because the local regulations do not cover provisions or regulate requirements for collective dismissal, meaning that some of these countries around the world, but specifically in Latin America region, would have specific regulations and process that needs to be followed when a certain number of employees in a particular period are going to be impacted. This is what we call the collective or group termination, collective dismissal. And in these two countries, we don't have any of that. So we believe the process is much easier. And also, if you look at the severance and notice that is mandated by the law in the countries, and provided that those protected employees, and we're going to go into very much detail along the course of the session, but if the protected employees like sick leave, for example, or pregnancy are not going to be impacted, the termination can be quite straightforward. The next group that we have classified as medium complexity are those that are the countries where, terminations can be a little tricky. For example, Mexico is one of the countries that we have included in the amber color, and we consider that terminations, there is a collective process when the termination will result in a total or partial suspension of activities. That doesn't really necessarily happen in every restructure. And also, it kind of triggers a process that is very time consuming, it's long, it requires the approval from the labor authority. So at the end of the day, the standard practice and what most companies are doing is just terminated by the mutual consent, and therefore terminate individually. And termination with mutual consent requires the employee's agreement. So, there's a process to do that, and there are some requirements that can be followed to make this happen. But obviously, when you depend on another party to do the termination, then this can trigger additional complexities. Another country that we have included here is Brazil, because even if the law has this kind of a structured formula to calculate what is the package in case of termination without good cause, there's this FGTS fund, and there's also a penalty that can be applied. The practice is that litigation is very common in this country, and employees frequently would claim for additional payments. So in practice, you end up negotiating individually what the package is going to look like, and you might want to give some more to avoid the litigation. So that's why we don't think the termination is so straightforward as the other countries. But this is the criteria where we've included the color coding here. And then finally, the harder jurisdictions, again, are those that we consider relevant for the purposes of making a global reduction in force because these three countries, Argentina, Colombia, and Peru, have a strict process in terms of collective redundancy. So when a certain number of employees is reached, is going to be impacted in a period of time, then there's a collective process that needs to be followed, and this requires consultation and also approval from the Labor Authority or Ministry of Labor. So again, sometimes this process can be avoided by reaching mutual agreement with the employees, but depending on the number of employees, like for example in Argentina, threshold is calculated based on a number of employees in the company, and it's a percentage. So imagine the threshold is 15 employees and you're in 20 employees. You might be able to play a little bit with the numbers and postpone or maybe take some of the employees out of the list. But if you're way above those numbers, then you might not have that option. And therefore, we've classified this as a hard country because, you know, it doesn't mean that the reduction or the termination it's impossible or is always hard. It's just that there's a very strict process that needs to be followed and that you need to look at other requirements. In this case, the collective redundancy, that is the trigger that we've considered to color the country as red. Then moving into the next section, which is the planning and strategy, there's a whole other concepts that we always recommend to go through and to analyze when making the reductions in force. So first, the legal requirement, and I've touched upon this, understanding the local framework. We've done this color coding, but there are other elements to take into account. So once you know the countries that are going to be impacted, the number of employees, and the timeline, then it's important to assess what are the legal requirements and get not only the basic information, you know, the employees' data, the headcount, the salary, the years of service, but also what are the legal process that need to be followed. Is the labor authority needs to be consulted or just informed? Do I have this collective redundancy process that can be triggered? When is that trigger, etc. The timing, of course, I mean, sometimes these reductions in force are the result of, you know, there's a time that the timeline, the strict timeline that is being looked at from a global perspective, like the end of the financial year or the completion of an M&A project. And therefore, for planning, it's important to take into account what the date is and then work backwards to that and make sure you have sufficient time to complete the necessary legal process that, as I briefly mentioned, might involve consultation, might involve approvals, and might involve individual negotiations with the employees. Communication, another very important factor, because sometimes, you know, it's important nowadays, like everyone in this world of over communicating, perhaps whatever you're going to announce in one country is going to be immediately known by the colleagues in the other countries. So having global communications and having a very clear communication plan is key. Also, you know, you have to take into account the legal requirements, which is the first strategy that I will mention, because how are you going to announce that the, you know, the decision has been made to terminate certain number of employees if you're waiting for approval from the labor authority, or you still have to negotiate with the employees. So the messaging is very important, what is said and how it is said. Any written communication should obviously be controlled, but also the who and the how. Who's going to make the announcement? Is this HR? Is this the management? Is this the in-house counsel? Also, how is this going to be communicating? Are you going to do a town hall, or is this going to be an email? Or does the law require have a proper termination notice that needs to be provided, or in person or Zoom meeting? Like, do you need to have in-person communications, or can this be done by Zoom, WebEx, or whatever IT tool that is now available? So that is also important to align. Next obvious topic is cost and budgeting, and here it's important to understand that, you know, the global projects that we sometimes see might work. So sometimes we see, okay, we want to be consistent throughout the world and we want to offer severance of 2 weeks salary per year, and that might or might not work. Some, because, you know, these countries have very specific, and we're going to look into them, you know, the bigger countries or the countries that we frequently advise on what the law says in terms of severance and in terms of notice. But as I say, it's stated by the law. And also, also, there might be process for unilateral termination where you can just pay the statutory severance, but other times you have to go through a mutual termination agreement. So there might be a framework for what is typically being offered, but other times it's a matter of, renegotiating with the employees. So it's very important to understand the budgeting impact and ensure that everything has been accounted. Like, for example, notice period. Some countries, you might have notice obligations, and if you want to pay in lieu of notice, that is an extra cost that needs to be factored. And then finally, the last topic that I would mention here is the business case and the objectives. So just to understand that, the global business case that might have been structured when deciding the RIF might need to be accommodated to the specific country requirements. So we have some jurisdictions, especially when it triggers collective redundancy, that will require some specific business case that is mandated by the law. So not every business case is going to work. You need to have a specific one. And also you might have to provide evidence of that business case, like, for example, Argentina or Colombia. So it is important to make sure that that is worked on and that is prepared. And also, along with the business case, but link the objectives, like, what is the impact of those employees, like, through the process, the RIF, if that's going to disrupt the business. So that's something that needs to be planned ahead. And also for the employees staying, whatever message or communication that is being issued, it's important to factor how is this going to impact the morale, and prepare for that, so to minimize the risk for the company. So here, the key takeaway is to understand the whole landscape before the RIF is going to happen. So moving into the second hot topic that we have identified, hot topic, the second among the 10 things to look out is the rationale for the restructure. And here again, I would like Dan to give a little bit of a messaging or introduction on how, the need for a rationale for restructure might vary as opposed to what we're used to see from a US perspective.
Thanks again, Anna. The point about a business rationale, our U.S. clients don't always entirely grasp the importance of this outside the U.S. and in these LATAM jurisdictions in particular. In the U.S., I think we tend to think about the business rationale as sort of an after-the-fact explanation for why we may have done something to justify our behavior in a lawsuit, or a business rationale to, well, and perhaps we don't even need it, but if we are being looked at for violations of the WARN Act or of state WARN Acts and similar acts. In the United States, the business rationale is really sort of a reactive point. And oftentimes, as we're helping our clients with their international RIFs, the idea that the business rationale needs to be worked out in advance and carefully considered is sometimes a sticking point. And the fundamental reason is, in the United States, whether we can dismiss people is a relatively easy question outside of the union context, of course. We are free to dismiss people. It's just that we have to look at downstream liability for those dismissals. So we put together a business rationale to minimize the potential cost and likelihood of legal action after the dismissal. But in Latin America, the concern is really whether we will be able to do the redundancies, the dismissals in the first place. The business rationale supports the company's reason. It's going to take some time to be properly put together, and your lawyers will want to work these out with you. And it really is important that this not be given short shrift. It really does matter for your ability to dismiss employees later, because while in the United States we see very little, again, outside of the union context, of courts being able to order people back to work, outside the United States, this is a viable remedy and employees will take it. So I guess this is just sort of a point where I would say as US practitioners, I would pay extra special attention to this question of a business rationale. So back to you, Anna.
Thank you. So thank you so much, Dan. I think that gives me like picking up this point and presenting similar to what we've done with the heat map before. Again, green, amber, and red, those countries that have more of a stronger requirement to provide business rationale, a medium one, or a very low one. The grounds or the business rationale required differ country by country, and some countries just a genuine business case for a RIF would suffice, where in other jurisdictions they might need to align with the permitted grounds under labor law, and sometimes you might have just to allege what's going on, what are those grounds, and in other times, in other examples, you might have to show proof of the supporting decision, like if there's there's an economical difficulties, you might need to provide the data and the specific information that supports that. So going into, and that's also important because particularly when the RIF triggers collective dismissal, and you've seen that in the red are those countries that have a collective dismissal process, there is an approval required. So there's not only consultation, but also the labor authorities, the labor ministry are going to look into this. And that's why when you need to have their authorization, there's more information and requirements to support the business case. So looking at the jurisdictions as an example, to start with Argentina, the legal requirement to justify the reasons behind the decision of a collective dismissal need to be set up, and you need to have what is called a crisis preventing process, the CPP, that needs to be initiated, and that involves consultation with the union. The reasons required are adverse economic events, so you need to have economic difficulties, and although there might be a possibility to execute determinations without the agreement under this process, then you also need the approval from the labor authority. So the business rationale requirement is kind of high in this case. In Chile, although there's no government authorization, the termination due to business necessity needs to be alleged. So you need to explain what are the grounds for the termination. You need to have a business rationale, but in practice, the requirement is not so hard, and that's why we've included it into the amber color. And although the employees could claim for a fair dismissal, then the grounds for this justification are basically less strict, and you can ultimately follow the termination with an agreed package. In Colombia, again, if a collective dismissal is triggered, the employers must provide the Ministry of Labor information that evidences the economic, technical, or commercial situation of the company. That requires the need to make the termination. That's why the collective redundancy process is quite strict, and it's time consuming, it's very long, and you need to get the approval, and therefore in practice many times employers often choose to go for the mutual agreement with the employees, and that involves obviously the additional negotiation with them to try to navigate this process. Costa Rica is again green because there's no legal requirement to provide a reason for the termination, although the employees might ask for an explanation of the reasons, but there's a statutory severance and notice mandated by the law. And as long as the process is followed, it shouldn't be, and there's no discriminatory or protected employee status, then the business rationale shouldn't be an issue here. Similarly, Mexico, although we've put it in red, because when there's a total or partial suspension of activities and the collective process is being followed, you need to provide all sort of information and the legal requirements for the reason of the termination to get the approval from the labor board. In practice, again, it's sometimes the approach taken, and that's why Mexico wasn't red previously, it was amber, because the employers often choose to go through individual negotiation with the employees and executing mutual agreements for the termination. And then finally, Peru, the collective process, similar to Colombia and Argentina and Mexico as well, it's long and complicated, and the ministry rarely approves the collective terminations. And also the dismissal has to be for cause. So it's very typical for employers to go through mutual agreements to avoid, having to work on this business rationale and having to set up all the sort of explanations and business justification that the law requires. Enough of that. Business rationale is something that needs to be looked at and considered. But there, as I was saying, there's in practice ways to navigate that. And although you might have to go through that process if you are into a collective redundancy process, collective dismissal, because the threshold of the employees to be impacted is reached, there are other ways to navigate that and be able to do the RIF with proper planning and strategy. And now I'm going to pass it on to Juanita and Dan, who are going to guide us through some other key planning elements on this topic.
Thank you, Anna, and hello, everyone. In this comment section, we are going to cover the different requirements around the selection of employees to be impacted by reduction in force. To select an employee that will be impacted by a reduction in force in Latin America, employers must identify two main issues. The first one is to check whether there are any legal prohibitions in each jurisdiction where the reduction in force will take place that are triggered by particular protected characteristics. Depending upon country, the protections may vary. So the most common protections among countries in Latin America cover pregnant employees, employees on maternity leave, parental leave, paternity leave, breastfeeding. Also, it covers employees on sick leave or employees with that have a disability, employees that have been victims of sexual or labor harassment and who have filed a complaint will be also protected. This is the case for Costa Rica and Colombia, more specific, and employees representatives, trade union directives, members of health and safety committees, they will be also protected. In some countries in Latin America, employees under any of these characteristics cannot be terminated and must be, employers must wait for employees to return to work to proceed with the dismissal. However, there are other countries such as Chile, Colombia, Costa Rica, where employers may terminate the employment contracts without authorization from the employment authorities. This is the case for Colombia, where the Ministry of Labor may authorize the termination of an employee with a disability or with a sick leave, maternity leave. These authorizations with the ministry require a justification. In most cases, the justification can be the existence of a just cause of an objective reason of termination. For example, in Chile, the authorization will only be granted when employees are engaged through fixed-term employment contracts or if there has been a misconduct that configure a cause. As an exception, some countries also allow employers to negotiate the employment termination with the impacted protected employees. This is also the case for Colombia. For these employees to agree on a mutual termination, employers must enhance significantly the payment of the statutory benefits. So in that case, employees will negotiate, in addition to the payment of their severance pay and notice for some countries, an additional amount or some additional benefits. That's the first issue that I was mentioning. The second issue would be for the employers to identify whether there are any other documents at the company, such as policies or collective agreements that contain restrictions on how employees can be selected and how the process must be applied. For example, some collective agreements may specify particular considerations that must be taken into consideration. For example, a collective bargaining agreement may provide that the last person to join the company must be the first person that leaves the company and is the first one that is being terminated. Finally, regarding this section, we must consider that Also, most countries in Latin America don't have a legal selection criteria. In most jurisdictions, employers must select the employees impacted on fair, objective, and non-discriminatory grounds, which means that employees should be not selected on race, age, gender, or any reasons that can be considered discriminatory. Daniel, do you have any comments on this?
I do. Thanks so much, Juanita. I think that we come back here for me to keep dragging us back to the US, but only as a point of context. Looking at this slide, if we were talking about a RIF in the US, we would only care about the purple square here, protected characteristics. The other two would be minuscule in how much we would be focused on them. But in Latin America, the one sort of overarching issue is that protected characteristics are in large part sort of a binary question. Is the person or isn't the person protected? And then if they are, what does the law say about what may or may not happen to them? In the US, we have no similar assurance. It is not binary, it's super gray. Can we dismiss this employee even though they are in whatever 6 categories or something? The role of objective criteria is incredibly important outside the US. And the idea is to ensure that the selection has been, as Juanita said, fair and consistent. In the US, as I said, our primary consideration, as we know, is analysis of the data. I'm sure there are plenty of people on this call today who have worked with our best-in-class people analytics group to process the disparate impact analysis of a US RIF. We wouldn't do that outside the US. There would be other things we would do, but they would probably be more closely related to the role of objective criteria and the restrictions in other instruments, rather than a focus on protected characteristics as we would have in the United States. So with that, back to Juanita to pick up on consultation.
Thank you, Daniel. So moving into the next topic, another relevant requirement for employers to take into consideration is whether consultation on the reduction in force may be required. For example, in most Latin American jurisdictions, whether employers have a legal requirement to consult unions will depend on whether the number of impacted employees trigger a collective redundancy. Union consultations usually take place during collective dismissal procedures. This is the case for Argentina, Brazil, Mexico, and Peru. They are the countries that we have said that require a collective consultation in case an authorization from entities in case they triggered a collective redundancy. Union consultation may also be triggered in individual redundancies when it is provided by a collective bargaining agreement. In Argentina, for example, when a collective bargaining dismissal is triggered, employers must notify the Ministry of Labor of the collective redundancy, and they must initiate a special procedure called a crisis preventing procedure. This is something that Anna had already mentioned. Along with this procedure, employers also have to give notice to the union and consult with them in an effort to agree on the termination. If they don't reach an agreement during the procedure, employees may proceed with the measures without union agreement and once the CPP is closed. In Brazil, when there is a collective redundancy, employers must discuss the terms of the collective dismissal with the union before the dismissal are implemented. However, no union's approval is required. It is just an informal requirement, but there's no need of approval. In Colombia, there is not a legal requirement to consult unions. However, employers must inform its employees that it will request a collective dismissal authorization. This requirement must be done simultaneously with the this notification to employees must be done simultaneously with the requirement to the ministry or before filing the request of authorization with the Ministry of Labor. In Mexico, there is also no formal requirement to inform or consult employees representative of unions. However, if there are unions, if the companies have unions, from a practical perspective, it is advisable to approach the union representative and let them know about the termination and that the company will make the proper payment to avoid any union opposition. In Peru, as well as in Colombia, as well as in Argentina, there is employers need to consult with the unions, and if there is not a union involved, employers must consult with the employees directly about the termination. So this is the information about consulting with unions, and now we are going to move to the requirement to involve labor authorities. Also in Latin America countries, where the impacted number of employees trigger a collective redundancy, usually require the authorization of labor authorities before the employers can actually implement a reduction in force. The consultation or notification requirement can be provided by law or can be provided by a collective bargaining agreement. Some countries where there are legal notification or authorization requirements are Argentina, Colombia, Mexico, and Peru. In Argentina, as we were saying before, if a collective dismissal is triggered, a crisis preventing procedure, as CPP, must initiate with the Ministry of Labor. Under this procedure, the ministry will decide whether the CPP is accepted and will summon the unions or the employees representatives to a negotiation meeting. In Colombia and in Peru, if a collective dismissal is triggered, employees must obtain authorization from the Ministry of Labor. In each country, the employment authority that is going to grant the authorization will be the Ministry of Labor. In Mexico, under the understanding that a collective dismissal is triggered, employees must obtain authorization to implement the redundancies from the Conciliation Arbitration Board, which is the corresponding authority in Mexico. Also, in theory, most of these proceedings have a time frame provided by law. For example, in Colombia, the ministry has 2 months to assess the request. In practice, is that in most of the countries, the process takes longer than the time provided by law. The authorization request usually implies the delivery of companies, corporate information, employment-related information, and any information that shows the reason why the redundancy is going to take place. In that case, it will be any financial, technical, administrative, commercial information that shows why the redundancy must take place. Among the information related to employment-related matters, it's usual that the ministries require a copy of the headcount of the company, a copy of the salaries that the employees receive, all information for them to do the assessment and decide whether they do or do not grant the authorization. This is it for the authorization of the labor authorities, and I'm going to turn this to Anna for her to explain what is the position regarding severance costs and benefits.
Thank you so much, Juanita. And important information, the consultation and the labor authority involvement, very different to what we would see in other countries and particularly in the US. But if it triggers collective redundancy, it becomes a key milestone for the process that it's important to be prepared of. And another thing that is important to be prepared of is the severance costs and the benefits that are that needs to be the position with regard to the benefits in a RIF in the Latin America countries, because this is one, if not one among the most important things that needs to be planned for when it turns to planning the RIF. So understanding, as I mentioned, these countries, I think all of them basically would have a statutory severance that is defined by the law. So as Dan said, you know, kind of the rules are there, and we've set up in this slide. I'm not going to read through that, as you're going to be able to look at the slide, but there's a clear formula, and there might be different requirements. So for example, in Costa Rica, you know, it's a number depending of the employee's salary. There's a different threshold for the salary that to calculate the severance that will be triggered. And there's, you know, if the employee is above this salary, there's going to be a number of days triggered for this length of services, for this seniority, and below that salary, there's a different one. So, but there's a clear formula to follow and to calculate the severance in order to you know, understand what the expectation and what the from the employee is going to be, and what the law, what the courts are going to grant to the employee in case this ends up in court. There's also, and moving on to the next slides, there's also a notice period that it's again defined by the law in the countries. Good news is that the laws that have notice periods, so Colombia and Mexico wouldn't, and Peru, but the others that have notice, there's a possibility to pay in lieu of notice, the pilon. And that, as I mentioned earlier, it's an important factor to take into account because it would increase the cost. So if you have certain notice and you want the termination to be immediately, you don't want the employee to work through the notice, then that's a cost that need to be regarded. In terms of other benefits that might not be defined by the law, but are being provided to the employees, like RSUs or bonus or commissions or incentive, these are generally subject to the contractual arrangement. But what we see in practice is that it also depends on the interpretation. This needs to be looked at, and it's important to take into account that, you know, even if the plan says the employee needs to be an active employee, the individual has to be an active employee at the payment date. If, for example, the termination is 2 days before the plan was due to vest and the payment would be made, it can be considered that the company is acting in bad faith, and then the court would grant the benefit. So it's important to, you know, review those in advance as well and analyze from a country legal standpoint if there's any risk to provide that too. And then, in addition to what the law says, there's also market practice. And as we mentioned before, there are some countries where individual the determinations can be done by the individual decision of the company, but it might be that because of the analysis of the circumstances, it is more convenient to go through a mutually agreed termination in order to speed up the process or in order to manage the risk of litigation. And in other countries, it's just the approach that is highly recommended to go through, like Mexico among them, to go through a mutually agreed termination. So that's kind of the market practice. And although the law might say a statutory severance or notice, we also have to look if the practice in the country, in this Latin America region, would also involve some additional enhanced payment. Like, you know, we've seen in some of these countries, I'm thinking of Brazil, for example, where, you know, you might want to budget a little bit extra just in case there's this litigation and you want to end up reaching an agreement. So that's why it's important, like if you don't, in those countries where mutual agreement is the standard practice or is the recommended approach, it's important to have a plan B and have some room for negotiation in order to be able to conclude the termination. Because, you know, if you need the employee to agree, then it's key to have some plan B defined in order to make the termination. Moving on to the next topic, which is the timing challenge. I've briefly touched upon on this, but it's, you know, as important as severance and all the other factors that we're considering. So if we need to take into account not only the appropriate time of communications and align with, you know, going back to my previous point in the strategy planning, like there's a global announcement and you want to notify all the employees in the different countries, the Latin America region needs to be looked at specifically, and particularly when the collective termination process is triggered. As Juanita was explaining, there might be consultation obligations, there might be labor authorities that need to be involved, and that triggers a longer process, sometimes considerably long. So it's going to have an impact on the planning. So getting the communication right it's important. Sometimes we see that there's a tendency of just quickly disclose that this is going on and then move on to the next stage of the business, the next phase. We always recommend to look at this carefully and analyze the impact in each country, because particularly in those countries where a mutual agreement is required, you need to go through the mutual agreement separation route. If you a communication stating that the terminations are going to be made might jeopardize the negotiations and might be used by the employees for claiming that the termination is a wrongful dismissal, unilaterally executed by the company. So again, the timing and the global announcement need to be looked at carefully. Also, it's important to factor the information gathering, particularly if the collective termination threshold is being reached and you need to go through that process. There's a lot of information that needs to be collected, and it can be a time-consuming exercise. For example, if you need an economic analysis. Review the protected employees, because that can also have an impact. So if the employees are on sick leave, and we've seen it sometimes on the global reef, then suddenly the employees that were supposed to be terminated are off sick, and therefore you cannot go on with the process, and they need to be left on standby until the whatever protected characteristics end, if they do. Consultation, a very important aspect to take into account the consultation requirements or information to the labor authorities on the timing planning. Also, I would like to add this, because I see this coming as a trend more frequently in the Latin America countries, is the third-party employer involvement. And we see some companies are starting to use more and more the PEO, or the employer of record, and therefore technically these would be their employees of the employer of record. And therefore that needs to be alignment with these entities in order to execute the termination, and you need to agree the timeline or the process, and there might be disagreements on it. So this is another thing, another element that might have an impact on the timing planning. Also, very important is the holiday periods. There are some, public holidays in the different countries that might be impact, and that might be very relevant, but also some customary holidays that people will take. So like in the holiday, the Christmas period, when for the countries that celebrate it, and most Latin America countries will do, it might not be a good moment to try to negotiate terminations, because employees might have already booked for a travel or to be away from the office. So it's important to look at not only the public holidays, but also vacations that might have been already booked by the employees, in order to set up the timeline that is going to be required for the rift. And then also there might be some, I'm talking all the time about the countries where a mutual agreed termination is required, and that's going to be the standard in most of the Latin America countries. And there are things, practical things that we also have to take into account, like I briefly mentioned this, the vesting dates. If there's any incentive plan that is going to end, or there's an RSUs that are vesting next month, or there's going to be a school year or a close retirement date. So these are all dates that individually are going to have a huge impact on the employees, and that might make a very simple case very complicated if this is not looked at. So in terms of timing, sometimes you can anticipate, sometimes you can't, but we always ask employers to be conscious of this type of things, like if the incentive plans are going to be due in October, then maybe don't make determinations a week before that date, because you're going to have plenty of claims if you're not planning to observe that, or just grant the incentive to everyone. But that's going to be the key point that all the employees are going to challenge, and that are going to make the negotiations much more complicated when negotiating with the individual employees. And then I'm going to pass it over to Juanita to talk about some logistics and practical issues to take into account on the implementation phase.
Thank you, Ana. Yes, there are some relevant practical steps that must be considered for a multinational, particularly for a U.S. company. The logistics and the practical implementation matters in Latin America can create some difficulties. One of them is how to deliver the news and how to hold the notification meetings. Employers must determine whether they can have an in-person meeting or whether they need to have a remote meeting. We often say that in-person meetings are best. However, for big group of impacted employees, and in case where there is no HR function or there is a limited HR function, this may be difficult. If remote meetings are required, employers need to consider on the logistics to obtain documents signed. Some jurisdictions require wet signature, for example, Mexico, and then employers will require to coordinate the logistics to obtain the employee signature. Other item that employers must consider is who will attend the meeting and who will sign the termination documents. Employers need to make sure to have appropriate representation, and this can mean that they will require to have a power of attorney for the person that is going to attend the meeting and or is going to sign the documents. This is one item that should be confirmed early on so that any decisions and terminations are not compromised by invalid, inappropriate, or unauthorized representation. Other item that must be considered is when entering on mutual termination agreements, some Latin American countries require that the documents are signed or ratified before public notary or the Employment Labor Authority. These are the cases for Argentina, Chile, Costa Rica, and Mexico. Other item that must be considered by employers is if employees are part or members of a directorship, employers will require to proceed with the employee's removal or resignation. Companies must consider whether a replacement must be appointed and whether there are any nationality or residence requirements for this appointment. In some cases, directors or shareholders resolutions may be required for forced removals of directors. And finally, when collecting company property and equipment, employers must also consider when and how this will be collected and whether it will be cheap on the way back to the headquarters or what they are gonna do with the equipment collected. Anna, I'm back to you.
Yes, thank you, Juanita. So moving on to the 9th topic, which is the post-employment considerations. And this is, it's important to plan ahead the post-employment issues because they will obviously have an impact also on the, and we've mentioned this in this circle a little bit of what all needs to be thought of or planned, but it will have an impact, and it might have an impact on the negotiation on the whole termination process. So first, it's taxation. What is the taxation of the severance? Is all the severance free from taxes, or does it have a different taxable treatment? And what about the enhanced severance? If you're offering something extra, what is the treatment on that? And that is important for the employers to understand what's the position in the different jurisdictions and the obligations towards the redundancy. The second one is a data retention, like what are you going to do with the data that you tracked from these employees once they're gone? Is there an obligation to keep it? If so, for how long? Data privacy rules are very strict in the Latin America countries, and they're developing quickly, and they can lead to important fines and consequences for employers who breach that. So the fact that they're no longer your employee make it even more important to look at the data privacy aspects and make sure you're covering all the obligations in terms of data protection. Social Security, there's generally in terms of Social Security cover, like the local Social Security entity of each country that covers health, that covers pension. So all those aspects need to be looked at because there might be notifications, there will be notifications that need to be made after the termination, and some of them will have very strict timeline in terms of how you can do it and when. So it's important to look at. Then restricted governance, and this is relevant to many employers because they want to make sure that whoever employees are being terminated, and particularly those at a certain level, are going to stick to those covenants that have been agreed throughout the employment and for a certain period. Some countries will have, like Colombia, have a very clear view that these are not permitted, and therefore whatever restricted covenant or non-compete agreements will not be enforceable. But other countries like Peru, Brazil, or even Mexico, even though sometimes they can be questionable, the practice is that they can be admitted or they can be accepted upon certain requirements, like the limitation over time that is for a particular position. So there's a commercial interest in that, and most importantly, there's a consideration, there's a payment being made to compensate the non-compete for the employee. So the one aspect is look at the non-restrictive covenants that you have in place and make sure they are enforceable, and if so, decide if you want to enforce it, because given that it might require in some of the countries the payment of a consideration, this becomes more of a decision on whether the additional cost towards the benefit for it, it's interesting for the company. Confidentiality, yes, employees will continue to be bound by the confidentiality obligations post-termination, but it's always good practice to remind the employees about their obligations, look at the clause that they have in the agreement and maybe reminding the mutual termination agreements of these confidentiality obligations, to refresh that for the employees and make sure, particularly in most senior roles, that they're being respected. Outplacement services might be a good option, again factoring cost here, but it might be a good option to offer for employees to make this the transition easier, and also to get them into a mutual termination agreement, and also might help protect the company's reputation in the market if you're offering some additional benefits. Debriefing, as in any project, it's important to look at the lessons learned, what can be improved, impact on the cultural factors, impact on those employees that are staying. And that moves me to my last topic, which is employee relations. Not only for those employees who are leaving, it's important to make sure the transition is being planned and is being done in an efficient way, but also for those who are staying that might be going through a difficult situation, having their colleagues leaving the company. It's important to manage the employee relations and address any concerns that might be coming up. And then moving on to Juanita for our last topic, which is the risk that the RIF in the Latin America region might involve.
Thank you, Ana. In this part, we will talk about the risk and the consequences of a unilateral termination. These may vary depending on whether this takes place under an individual or a collective redundancy process, under an individual redundancy for those Latin American countries where it is legally possible to terminate employment without just cause. That is the case for Argentina, Brazil, Costa Rica, Colombia. Employers may face the risk that employees claim the payment of severance if severance has not been paid upon termination, or in the case for Argentina, employees can request the payment of an increased amount in addition to the severance for unfair dismissal. In Chile, also there is a legal requirement to justify the termination the termination provided by law. Employees may allege a wrongful termination and claim a surcharge payment on the amount of the regular severance. In Mexico, if an employee is terminated without just cause, that person will be entitled to claim a wrongful dismissal, and that person could also claim the reinstatement or the continuation of the payment of salaries up to 1 year. If employers have not paid the severance, they will be also entitled to the payment of full severance amount. In Peru, because the termination without cause is unlawful, employees will be entitled to reinstatement or to a compensation for arbitrary or unfair dismissal. In addition to these items, employees can also claim moral damages and indemnification if they consider that the termination of their employment has resulted from discriminatory acts. This usually happens in Brazil. This is under an individual redundancy. Under a collective dismissal, employees in some countries may claim as well the reinstatement and the payment of all the salaries and benefits that they didn't receive during the time they were not working for the company due to the termination. And this can also lead to collective conflict and union intervention. This usually happens in Argentina. But basically, those are the main risks. Payment of severance, payment of benefits if they have not been paid, reinstatement, or moral damages claims. Daniel, do you have any comments on this from a U.S. perspective?
Sorry to interrupt. I'm going to make just the comment is follow the timeline, ask your counsel about the timeline and follow the process. Ask for a map of it in the beginning. We can do that. Over to you, Anna, so we can get key takeaways. I see we just have a few seconds.
Yes, so very, very quickly, we want to leave you with some key takeaways, especially taking into account the risk that Juanita has described. So basically determine the ultimate goal and work backwards. So what is what you want to achieve, and then plan for that. And in the planning, take into account all the notions that we've described: the business case, the timeline, the cost, the negotiation, consultation requirements, the notice to the labor authority, etc. Factor what is the priority? Is it a fast process, or is it keeping good employee relations, or is it reducing the costs? And then keep that priority in mind for the planning, because if you want it to be fast, then probably you might have to pay a little more. And if you want to keep the employee relations, then you might have to expend more in this, outsourcing or placement, and on other benefits that can be given. Get the full picture from local HR and central headquarters. This is key. If you have good local HR that are very familiar with the landscape, that's going to be super helpful in planning. But if you don't, then you need to plan a little bit more, because you're going to need more local input and more local support. Get the view of what resources are available and plan accordingly. And then last but not least, be prepared. And be prepared because there can be, risks can turn out very easily or can be a bit more complicated, and we have to, and your counsel will always help you plan if there's any litigation or if there's going to be industrial action. What's the worst case scenario that you need to look at, and what you need to have ready and considered to be ready to be fully in the place where you want to be when you start your RIFT.
Before we turn into pumpkins here and run out of time, let me give you all the CLE code. Please grab a pen and paper. The CLE code is SS as in Seyfarth Shaw 7189. That's SS as in Sierra 7189.
Thank you so much, Dan. With this, we conclude the program for today.